Welcome everyone, this is Amer from U Counsel. When you go to court, when you commence a court action, you are asking the court to grant you some sort of relief. Either it's in the form of money or it could be something else. So what are different kinds of reliefs that you can ask from a court? It is important for you to understand some basic concepts so you can include those reliefs appropriately in your statement of claim. And if you don't ask for a relief, the court generally is not going to grant you that relief on its own. So in this lecture, we'll talk about those legal and equitable remedies. We begin with our usual disclaimer that this course is not legal advice. So if you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. Now, what is a remedy? A remedy is a relief that you're asking from the court. And as I mentioned, that a judge or the court will not award you a remedy if you have not asked for it. So it's important for you to include that. And then also that the relief or remedy that you're asking must be within the power of the court to grant. And this is not the topic we're covering in this lecture, but it is important for you to understand the jurisdiction of the specific court which can grant you the relief. A common example could be that if you want the defendant, the wrongdoer, to pay you, let's say $50,000 for the breach, you cannot go to small claims court and ask for that relief because small claims court has a limited jurisdiction of $25,000. So even if you are successful in your trial at a small claims court, you will only get the relief for $25,000 because the judge does not even have the power to grant you more than $25,000, right? Similarly, if your matter is before a human rights tribunal, now a human rights tribunal only has the power to deal with human rights issues, the discrimination issues. If you ask for a breach of contract remedy, which is unrelated to a human rights issue from a human rights tribunal, it will not award you that relief or remedy because it does not even have the power to give you that relief. So it is important to understand both. What are the kinds of remedies that you can ask from a court, from a judge, from a tribunal, and whether that judge, that court has the power to actually grant you that specific relief. Now, there are two basic types of remedies. One is called legal remedies, and the second one is called equitable remedies, and we will explain what are these remedies and what are the differences between the two. And to understand their distinction, we will quickly talk about a brief history of where these remedies originate from. So a few centuries ago, what used to happen was that if people had a legal dispute, they will go to a court of law, and the court of law had a set of rules or principles, and they will apply those principles in those specific circumstances and will come up with a resolution. And sometimes the application of strict legal rules would result in harsh results, harsh resolution of that dispute, and people had no choice but to either accept it, or what they will do is go and appeal it to the king. And then the king had the power to look at the fairness of the entire issue and grant certain reliefs on the basis of moral values that the king had or the society had at that time. So some rules were harsh, and then they will go and appeal to the king. And what happened was that a lot of these cases were going to the king, and king was busy, and king then assigned this duty to chancellor, and then chancellor formed this court called chancery or court of equity, and then a lot of these cases will go to the court of equity. So this was not a court of law, this was a court of equity, and it's not considered a legal resolution of the dispute. So it was based upon certain natural fairness principles based on the moral values of the society. So at that time then, in the Middle Ages, there were courts of common law and court of equity that were developed providing different functions. And as I mentioned, the equity or the court of equity will apply principles of natural laws, basic fairness principles, and then use their discretion in certain circumstances where the rigid application of the law will result in an unfair resolution. So, but presently, the courts, all of the courts in Canada have the power to apply both law and equity, and there was an act, called the Judicature Act, which allowed all courts the power to exercise the power to grant legal remedies and equitable remedies. But what you want to keep in mind is that the distinction between legal remedies and equitable remedies remains. So it is important for you to understand that there are two different kinds of remedies, and the court may have the power to grant both remedies, but it is important for you to understand under what circumstances you will ask for legal remedies in your case, and under what circumstances an equitable relief will be appropriate. One example that comes to my mind about, an example where the strict application of the law will result in a harsher resolution. Back in 2009 in the UK, one person, call him John, he had intended to give his farm to another person, David, when he would pass away. And so he had created a will in which he gave his farm to David, and David had worked on this farm for 28 years, so there was some understanding between the two. And John created that will, but that will got destroyed. So the will didn't exist, and John passed away. So when John passed away, there was no will in existence. David had an understanding that there would be a will that will grant him the ownership of the farm, but the will was gone. So under the strict application of the law, the rules that will apply is that property, that farm, will now be transferred to John's relatives, blood relatives, and there are specific rules about when someone dies intestate. Intestate is when someone has no will and he or she passes away. So those rules will come into effect. And in the resolution, or the end result of that, will be that David would not get his farm. So David applied to these courts, and under the strict common law rules, David would not have gotten the farm. But the court then applied an equitable principle called equitable estoppel. We're not going to talk about that principle today. But under that equitable remedy, the court was able to grant the relief to David so that he could have the farm as a result. So this is one example of where the principles of equity will come in to assist an aggrieved party and provide a resolution which is more fair, as opposed to a legal resolution, which comes in unfair results. Okay, so let's talk about legal remedies. It's important to understand that the court's basic power is to award monetary compensation, which is called damages, right? So a simple example could be that if you enter into a car accident and you have an injury, a broken leg or something, the court will grant you certain money as a result of that injury. So monetary compensation is the most common way the court grants any relief. And then there are different kinds of damages, and it is important to understand, at least fundamentally, that there are different kinds of damages, and they have different criterion in order for you to get those damages. So what are some of the common types of damages? First one is called compensatory damages. Compensatory damages are called actual damages. These damages are for an actual loss. So an example could be that you sold your car to someone for $30,000. That person paid you $5,000 as deposit, took the car away, but did not pay you the remaining $25,000. So your actual loss based on that contract, based on that deal, is now $25,000. So you go to court and ask for those compensatory damages for your loss of $25,000. So that's it's the most common type of damages, compensatory damages. Then there is another kind called general damages. These are damages for non-monetary loss that arises from that breach of contract. An example could be human rights damages, where someone claims that he or she has suffered injury to their dignity and feelings of self-worth. And so these are non-monetary losses, or losses or damages for pain and suffering and anxiety. All of these damages could be general damages. Punitive damages, as the name implies, that these are damages which are not compensatory damages. These damages are essentially to punish the wrongdoer, the defendant who has done something wrong, and they act as a deterrent for the society so that others should not conduct themselves in the same manner. So punitive damages is another form of damages. Liquidated damages, it's a reasonable estimate of the actual loss. So sometimes it will be hard to figure out the exact losses when a breach occurs, and parties can agree to a reasonable estimate. It has to be a reasonable and fair estimate of the actual loss, cannot be exaggerated, cannot be excessive, or it may be considered a penalty for the default. So liquidated damages is another example. A lot of times, a common example is if you are a contractor who has provided certain services, the amount of services were agreed upon. Let's say it was a plumbing job, and you had agreed to provide that plumbing services for $2,000, and you provided those services, but the other side did not pay for it, and you rendered an invoice. That will be an example of liquidated damages, because the value of the actual damages or loss was set and agreed upon. So liquidated damages is another example of damages. Aggravated damages is for the aggravation of the injury. So if the conduct of the wrongdoer caused aggravation of certain injuries, and these could be mental or emotional injuries or other kinds of injuries, then you can get aggravated damages for that. Then there's damages called consequential damages, which are indirect damages or incidental damages. So these are damages that are not arising from the actual breach of the contract, but being affected by the wrongdoer's conduct. So an example from a famous case, I believe Hadley versus Baxendale. In that case, a party, a manufacturing facility, required a part from a different location, and once they had the part, they will process certain orders for other clients, and these were orders in a significant amount. So they relied on a courier company to get those parts and deliver them those parts in a specific time period. And once they had those parts, they will be able to process those orders. And what happened was the courier company failed to deliver those parts in time. And as a result of that failure, the company, the aggrieved party, then lost significant amount of money because they could not process the orders in time and suffered significant loss. So this kind of loss is really, the breach is simply that the courier company could not deliver the product in time. So in normal course of action, if you pay $200 for the courier company to deliver that product, and if they fail to do so, then your normal damages will be $200 because they failed to complete the contract. But in this situation, that failure to complete that contract resulted in then $1 million or so of losses, and so those losses were incidental or indirect losses. They're called consequential losses. And in certain circumstances, not in all circumstances, you can't go around suing courier companies for all kinds of indirect or incidental losses. There is a specific criteria for you to qualify for these kind of losses. So there could be consequential losses that the court may grant as well. Now, with respect to equitable remedies, the most common equitable remedy is called an injunction. An injunction essentially is requiring a person to do something or stopping the person, prohibiting the person from doing something. An example could be that a developer is clearing the land for a major development project, and there are some old trees on the property, and they will end up cutting down those trees, and you believe that the developer should be stopped from cutting those trees. Then you will bring an injunction in the court and get a court order, which is an equitable remedy, which will stop the developer or any other wrongdoer from doing something that they're doing. Or similarly, if someone is not doing something, then you can bring an injunction to compel that person to do something. So injunction is an equitable remedy that is available in courts. Specific performance is another equitable remedy. In this situation, the court can require a person to perform a contract. For example, you purchased a house for $2 million, a small house in Toronto for $2 million, and you paid your initial deposit and everything, and you are ready and willing to complete the contract, but at some point the seller decides not to complete the contract, and the seller is denying you that house. Now, ordinarily, this is a breach of contract case and the court will award you damages, but in some limited circumstances, the court may actually compel the seller to complete the contract that he or she has agreed upon. So that requirement, that compelling of someone to complete the contract comes under the category of specific performance. And again, there are specific requirements for you to be able to get a relief of this kind. It's not generally available, but the relief itself is possible under equitable remedies. Constructive trust is another equitable remedy, and there are many more. Constructive trust could be where someone misappropriated your property. The value of property at that time was less. Subsequently, the value of property increased, or the person who took away or misappropriated the property then sold it off to an innocent third party, and you want to be able to enforce your right against that innocent third party, then you can claim for a constructive trust under equitable remedies. Rescission, it's an example of rescission could be that you entered into a contract which was validly entered, but you want that contract to be completely rescinded under the specific circumstances of your case, and then you can ask the court for that sort of remedy. Rectification is another remedy in which a court may rectify a specific contract in certain very limited ways, rectify the contract or rectify a will in specific circumstances, but the court does have power to grant this equitable remedy. So these are sort of basic legal and equitable remedies. There are few, there are many more, but it is important for you to understand why. Because when you commence your court action, when you prepare your statement of claim, you are describing the dispute, but you must clearly set out in the statement of claim what is the relief or the remedy that you're asking. If it's a monetary remedy, you have to set it out, whether you're claiming $100,000 or $500,000, you have to set it out in your claim. And also, what kind of damages? Is it a compensatory damages claim? Is it a liquidated damages claim? Is it a punitive damages claim? Or multiple of those? And you have to clearly set it out. And when you set these out, you need to provide all the necessary facts in your claim that justify the award of the remedy that you're claiming. So for instance, in the case of punitive damages, we know under the legal principles that the court will grant punitive damages only when the conduct of the wrongdoer, the defendant, was high-handed, right? And so if it was a high-handed conduct, you have to provide those facts in your claim that explain or justify that the conduct was indeed high-handed. If a contract or a breach occurred in the normal course of business and the conduct wasn't high-handed, and you claim punitive damages, those damages will not be awarded to you. So aside from your story about the dispute, it is important to clearly outline and specify the kind of claim, the remedies that you're seeking, and you want to make sure that whatever the factual basis is required to get those damages, to get those remedies, those are stated clearly in your statement of claim. So hopefully this gives you a sense of the legal and equitable remedies, their distinctions, and empowers you to obtain an appropriate relief from the court. Thank you for watching, and we look forward to seeing you in the next lecture.